Good morning. I would ask that Mr. Hines be sworn in. Raise your right hands. All right. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Mr. Hines, it has come to my attention that you recorded last time's hearing on February 15th. Is that correct? Well, I made notes, a lot of notes. I'm asking if you made a recording. I have no recording available for the public. I mean, did you record last time's hearing? On what, like any device or any kind of device? That's what I'm asking. Yes. And you heard my ruling that day. Well, it was pretty vague. I mean, you heard my ruling about the recording is separate. You did. Separate from, I asked about that. You made a motion and asked if it could be recorded, and what was my ruling on that? Well, it was a little confusing. You were talking about Oklahoma. I said you could not record in this courtroom. Okay, and I asked specifically about the GoPro cam. And I said you could not record in this courtroom. Okay, that was clear as a bell. There is nothing confusing about that. Okay, and you continued to record this hearing. Well, do I get a hearing on? Oh, I see, I'm swearing in. I'm asking you if you recorded during that court. Is this a trial then? Is this a bench trial I'm asking a question because I'm considering whether to have a contempt hearing for you right now. A contempt hearing? Okay, that's what I'm thinking about. Well, I would like to prepare for this. On my own motion, I can open up a contempt hearing. There's no preparation. There was no recording. I can have you put in DC today because of this. You understand me? Yes, sir. Because there was an order of this court. Okay. This court has given you wide latitude. Okay, this court has given you wide latitude. Okay, has given you every benefit possible. Okay, has been open to anything you need to do, but you came into this court after I made a ruling. Now before the ruling, you could argue you had a right to record. Okay, after the ruling, you did not. And my question to you is, did you continue to do so? I made as many notes as I could, not asking about that. I'm going to dispute it. There is no recording available. You can take that up, okay, and appeal my ruling, but you will not record in this courtroom. Yes, sir. Do you have a phone or a recording device with you right now? No, sir, I do not. There's nothing I have, nothing recorded right now. I'm asking if you have any device with you. Yes, well, I have this recording, but it's off. It's been off. It can be searched. There's nothing. I brought them, but do you have a cell phone with you? No, sir. I want you to give that to the officer, and that can be placed in the hallway. Do you have anything else? I have nothing. No cell phone. This is not on. It could be. Oh, hand that over too. I don't need it. I don't trust you, that's why. Okay. And it's a shame because I thought we had a relationship where I could trust you, but you came in here and violated a court order that was very clear. You asked for permission to record and I denied it. I heard your argument, Mr. Benjamin's argument, and I told you what the law is for me, that I am not allowed under the Louisiana Constitution to do this. Clear as a bell, that's all. I cannot allow recording. Do you understand that? Yes, sir. You have a transcript that's available to you if you choose. Okay, yes, sir. So normally I can fine you and I can hold you in contempt for this. Do you understand that? Yes, sir. And put you in the DC detention center for this. Do you understand that? Yes, sir. Okay, I'm not going to do that today because I'm fair, but I want you to be fair with this court, which means when I make a ruling, I expect you to abide by it. I've been nothing but fair with you, sir, nothing but fair. You file motions, I have them printed for you. The clerk's office is like your paralegal. Have you brought a written motion to us yet, or do we print them out for you? Well, I thought that's not our job. People file things, they bring them in, and they file them. Okay, have we stopped you from that? I've done it in other states. Have we stopped you? I'm telling you this in this state. No, sir, you have not stopped me from doing that. Okay, so we've complied with that. We've printed out things for you to file motions. I'm using experience from other states. Are you in other states? No, sir. Okay, you're in Louisiana. The clerk's office is not here to be your paralegal, but we have been very obliging to have you print out documents. Have you come in to sign them and file them on your behalf? I think that's pretty decent, don't you? Yes, sir, I appreciate it. Okay, then you go ahead and you ignore my ruling and record. See how I feel on that. Now I'm not going to hold that against you. If I did, I'd have you locked up right now. I'm not that guy, but I am someone who expects respect in this court. Do you understand that? And you have not shown that by flat out coming in here and recording when I told you you could not. The Supreme Court stops me from doing it, and I'm telling you, you cannot. Is that clear as it can be? It's very clear, sir. Good. Now we can proceed with y'all's motions today. I believe you filed 3 of them. Is that right, Mr. Hines? Yes, sir. I have the motions for. How does that? I'd like to make a statement. Which motions is this regarding? You have 3 set for today. You have opposition to motion for discovery by the city. Opposition to motion for discovery by the city. That, I believe, is the first one that you had filed. All right, okay, so the first one will be opposition to motion for discovery by the city, and then I'm prepared for motion in limine to suppress certain evidence. That's your last one. Right. I'm going to, by the order that they were filed. That's the last one, yes. So the first one you filed was the objection to motion for discovery by the city. Objection to motion for discovery filed by the city. I stand on the motion, and that was argued with the evidence that I have Fourth Amendment rights with prosecution. I was asking, in this motion you have argued prosecution should be barred by asking for discovery. That's the motion I'm talking about. The objection that you said the city of Natchitoches is time barred from asking for their discovery from you. That's the motion I'm talking about. Yes, sir, I'd like to just stand on what was written. Okay, Mr. Benjamin. Your Honor, the city objects to the substance of the motion. We know it's clear that under the rules of criminal procedure with respect to discovery is reciprocal. We filed a motion for discovery. The judge ordered that discovery be reported and complied with by the defendant. We complied with discovery, so we think there is nothing else to discuss of this, and we would defer to the court for its ruling. And Mr. Hines, what he is saying is it's fair that he gave you discovery and that he expects it back from you. You understand what he's saying? Yes, sir. Now, in your motion that you filed, I'm assuming you prepared, but I'm not quite sure, but you quoted Louisiana Code of Civil Procedure, Article 521A, and said that in this, it says a pretrial motion should be made within 15 days after the arraignment. Since the arraignment hasn't happened, they do not have a right to bring this. There is a problem with your motion, and the problem is it's out of date. That statute changed in 2020, so the argument you made is moot. Now the motion says pretrial motion shall be filed, made or filed within 30 days after the receipt of initial discovery, which they have received. So the law changed, your motion's out of date, it isn't appropriate anymore, and they have a right as soon as you filed for discovery within 30 days to ask for theirs. So not only is it fair, it's what the law is. So your motion is denied based on the fact that the law has changed, and it changed 2 years ago. You may need an updated book. So have you provided this discovery to the city? Sir, I intend to use only the prosecutor's discovery evidence. I have none to present to the court. There are no... Last time y'all were arguing about videos, you said you were going to provide Mr. Benjamin videos and information in a Dropbox. Yes, sir, that was before I got the packets of his discovery evidence. Okay, I wasn't sure what... So you received nothing in your Dropbox? No, sir, Judge. May it please the court, the city has not received not one scintilla of any videos, of any recordings, of any of the things requested. We would even argue that anything that was recorded, whether it be recorded outside of courts or relative to this, is still discoverable by the city because discovery is wide. It is. And we know, I think we understand that there has been a number of recordings. We don't have those. We know that. I know there's been recordings because we have seen portions of recordings on YouTube and such. Those are also discoverable. Everything he's recorded to everything that he would not consider evidence, whether it be evidence or not, just as he has a right to exculpatory evidence, we have the right to any culpatory evidence. We have a right to everything. You understand what he's saying, Mr. Hines? Yes, sir. In a criminal proceeding, there is open discovery, meaning that just like you have access to everything that's in their file, they have access to what you have that would have been important regarding this arrest. And so I'm not making any kind of ruling on the facts of this, as I've stated many times the last time hearing as well as I will this hearing. No evidence has been put before me, none, so I'm not making any kind of finding of fact because I am a trier of fact. So I tell you, you are required by law to provide him with what he has requested. If you have made videos in conjunction with this, if you have taken pictures in conjunction with this, if you've made statements or so, those need to be provided to the state so they have adequate right to prepare for their case. It works both ways. The door swings both ways. They provide you everything they have, you provide them everything you have. So I'm ordering you to do it as I expected you to do the last time. But again, you have a motion that requested that you were not required to. That's been denied. You are required to do so. So you need to provide any videos you've made in conjunction with this arrest, reports, any documentation. It's in the paperwork they gave you. So whatever their request was, you have to comply. Sir, I don't plan on presenting any evidence on my behalf. I'm using all of his. Well, it's the same audio that we have. What I'm saying is it's not as simple as just what you plan on using. He has rights just like you. He may not even use everything he gave you, but he has a right. I say he, being the state of Louisiana, has a right to request this documentation. And again, I say videos. I don't even know what's out there. All I know is that he and you have made or used the word video. So I'm saying video. If it's pictures of still pictures, that's what's required. Whatever is in his motion and he is required by law to receive them from you. Just like if you had a friend watching it and you didn't give him the name, you'd say, I have to give you the name of that individual because they are a witness. If there is no one in the presence, then there are no witnesses. And sometimes there's video, sometimes there's still pictures. So anything like that concerning this incident, he has a right to request it, and you have to turn that over. I am not familiar with the law that requires me to just provide blankets of evidence for discovery on my behalf. It's not blanket evidence. It's what's in his request, his required motion. It's what he's asking for. Things that surround this incident, you are required to produce. Okay, so I don't plan on presenting evidence, but I should still hand over some videos to Mr. Benjamin that in regards to this incident, that occurred on January 22nd. Here's the thing. He is required to give you exculpatory evidence, which means evidence that would otherwise prove that you're innocent. What if he wasn't going to use it? Should he just hold on to it and not tell you about it? I believe, sir, you're required to have that right because you requested it. Yes, sir, as part of my defense. Right, because I'm the defendant and prosecution has a higher burden. They have the burden of proof. They do. Okay, beyond a reasonable doubt. Right. And I'm in position of defending myself. Correct. And I invoke my Fourth Amendment rights. And I expect that when you come to court, you come to trial, you don't have to say a word. You don't have to say a word. You don't have to say a bit of evidence. You don't have to do anything at trial. But he has a right to any kind of information that you may have through discovery. Yes, sir. So that would not be considered a Fourth Amendment issue to demand of me to provide evidence to Mr. Benjamin. Is that the point to take? That is correct. That's not a violation of the Fourth Amendment. Okay, so you understand. So I'm ordering you to comply with discovery. I thought we resolved that last time. Please provide any discovery to Mr. Benjamin as he requested. He filed a formal motion against you. You have a motion from him that says he is requiring. From that motion you can, just like the one you sent to him, or you sent him a motion saying, I want these things, that's what he's provided to you. You need to respond to those. Now, if there's specific items that you feel you should have responded, then you can raise those and say, these items I didn't think there were necessary. You can do that, but again, I'm not going to legally advise you how to defend yourself. I'm saying you do need to comply with the order that's been given. You can't blanket say, I'm not giving him anything. Okay. Yes, sir. It just wasn't clear during the last hearing on February 15th. It sounded like if I was presenting evidence that should be what I provide to Mr. Benjamin. But now it's in response to his motion. That's why. I didn't write his motion. He did. The state of Louisiana, the city of Natchitoches, has given you a motion saying we want these things. You have to respond to those things, as opposed to you just saying to no. If there is a specific particular incident you want to say no, this item shan't go because of this, that, and the third, but you do have to respond to his request. And you haven't done that. You said that he shouldn't be able to get it at all, which again was this motion, which was relying on out-of-date law. But again, you need to provide him, and again, if not, address each specific one and say this is why, not this. Yes, sir, I understand. Even if it's a no, I still have to make the response. Well, it shouldn't be a blanket no, unless you're going to give him absolutely nothing that exists. So you're going to say he gets none of your information, he gets none of your discovery. I was under the impression if I was going to use something that then present everything, it sounds like I'm not sure. Okay, well, did you hear my ruling? Yes, sir. I want you responding to his motion for discovery. The second motion you had filed in an answer to City of Natchitoches motion to quash defendant's motion to quash as it relates to improper admission of facts not in evidence and request for reconsideration. Go ahead. Yes, sir. I stand on what was written. I have nothing else really to add to this argument. Alright, specifically what this appears to be is, again, I'm sorry, Mr. Benjamin, your argument on this. Judge, we've already submitted our response and our position to it to the court. Provided it to Mr. Hines very cynically and straightforward. We move to believe that he has not filed the proper procedure to, it seems he's trying to do is on attempt to an appeal. However, it's not in a proper form, proper procedure, and even if it were, he's out of time at this particular point because it's interlocutory. In other words, so that he has understood that there's no final judgment at this point. So his time for challenging that with a writ to a higher court has expired. So, Mr. Hines, have you received the City of Natchitoches' response here? Just like 30 minutes ago, I received the response. Okay, you did receive it, though, right? Yes, sir. I have it clocked in. It says, copy provided to the defendant this date of February 24th, when I have it clocked in. So you have received it February 24th. You received what he's saying in his motion, his response to your motion, the opposition to, yes, and the City of Natchitoches' motion to quash, defendant's motion to quash, as it relates to improper admission of facts not in evidence for reconsideration. I'm seeing which one you have. This first one I'm referring to says City of Natchitoches, motion to quash, to dismiss. Motion to dismiss. Okay, yeah, that was earlier. Yes, sir. So you've gotten that. Yes, sir. Okay, does that change your argument in any sort of way? No, sir. Okay, because what he is doing is responding, saying that why he doesn't think you should be able to really, in essence, this is a reconsideration. What you've asked for is another request to quash their attempt to bring you to court. My response is similar to the first time. Again, this is an ID request, and there is some language in here that I don't have jurisdiction over you. I just dispute that, and based on the fact that there was an arrest, and the arrest occurred within the City of Natchitoches, within Ward 1, State of Louisiana. So I do have jurisdiction over this matter. Further, I'm not saying that I'm going to deny your motion. As I said last time, I just feel that it is difficult for me to try to make a ruling on what you're saying based on what you're verbally saying in your motion and what Mr. Benjamin is saying. There is no evidence before this court, and as such there are two options. Either we have a hearing, which is in essence a trial, and then have a trial again, or you just have the trial. My position is that we have the trial, because you would be having to testify at your first hearing to present your side of this case, or they would. And so if you, especially if you're planning on not testifying and not presenting any evidence, then I'm going to wait for the trial to make a ruling on this. Now, after the trial, if I find that this was an unauthorized arrest and you were improperly arrested, then I can dismiss it and I quash from there. But I'm not going to do it in advance with no evidence just because your motions say one position and Mr. Benjamin's say another. There is no evidence in front of me, and evidence is taken by testimony, by documents that are submitted to the court and verified by a witness. There's evidence. Evidence is not what you're saying and what he's saying. So if I'm going to make a ruling, I'm not going to do it on paper. I'm going to do it from hearing facts and figures, whether it's from you or his witnesses, whoever it is. This isn't evidence, and as such, I'm not going to dismiss your suit or case against you. The case against you will continue. Again, you have a right to a trial, to have everything come out, but I just think this is premature, so I'm not dismissing it. I'm just denying it at this time. But it can be raised again at the trial, so your last motion is Lemony to suppress evidence. Yes, sir. In my case history, I have an affidavit for arrest warrant, and that I believe, that is evidence or testimony presented before the court, and that I have not reviewed. I mean, I reviewed an arrest warrant initially to assign the arrest warrant, but that's not evidence because it has not been brought to court. That is enough to be able to say someone needs to be arrested. It is not enough to convict somebody. And so this is a court where you have evidence and you make rulings whether to convict or not to convict. If Mr. Benjamin does not provide enough evidence that you are guilty beyond a reasonable doubt, then you will not be found guilty. That's what evidence, and that's what this court is for. It's literally a scale to weigh what is provided to me. At this point, again, I do not have evidence. Now, you have asked for certain evidence to be suppressed. None of that evidence has been put forward yet. So again, this is a little premature. It would be, you're welcome to request any type of testimony like this to me on the day of the trial. You could say, Your Honor, refer to the motion in limine. We asked this to be suppressed, and at that time I can make a ruling if it is. But right now there is no evidence in front of me. There's nothing about whatever was on your computer, what have you. That's not before the court. No one has said anything in this chair under oath as a witness, under oath about anything, and so you're a little ahead of yourself saying that it needs to be suppressed. It hadn't been brought as evidence. Yes, sir, I will resubmit the motion in limine to suppress certain evidence after arraignment. And you're allowed to do that. Well, I would not say after arraignment, but necessarily if that evidence is attempted to be produced. Again, there is a reason that the scale of justice is blindfolded, because you're blind to anything that comes before you until it comes into evidence in this seat. Everything else is just talking. Nothing that you and Mr. Benjamin have said today is evidence. It's just your position and arguments, but you will have an opportunity to have a trial at which he must provide enough evidence to find you guilty. If he does not, then you will not be guilty. So I mean, you'll have a trial, and that's the time when you can say this: evidence should not be brought. If it was not, well, for whatever reason, I'm not going to tell you how to argue your case, but for whatever reason, this case should not be brought and it should be suppressed. But again, that's a trial issue, and I suggest you bring it up as, but again, I'm not going to sit here and lawyer your case up. I'm going to deny it at this time, but I'm not going to dismiss it either. Again, you have a right to bring both your last two motions, which is the motion to quash and the motion in limine at the time of trial. So I believe that is your three motions that you had today. Am I right? Does that sound right? Is that the three you filed? Yes, sir. I would like to just clear up the affidavit for arrest warrants is in a particular category of not in the court. It's entirely only for an arrest to an effective arrest. Correct. Then it's not in the courts. Correct. I have not heard any evidence in this court as far as that was for your arrest, for a conviction. That's a totally different story. People get arrested all the time and they're never convicted. But this is the time at which you will be having evidence. When we set this matter for trial, I will have evidence. People will be sworn in, officers, laymen, or whoever. Again, you have the right to try your case and have evidence put forward or not. That's totally up to you. If you want to testify or not, that's up to you. That is your Fifth Amendment right not to incriminate yourself. I'm trying to prevent you also from incriminating yourself at an initial hearing because if you were to testify or argue on your behalf at that point, you would be in essence waiving your Fifth Amendment right. So I'm trying to prevent you from doing that, which you may appreciate or not, because I think that you have already said that you don't want to present anything, and you may not be testifying at that time. That's up to you. I'm certainly not asking you to do that. You have a right under the Fifth Amendment of the Constitution not to testify. It's Mr. Benjamin's job to prove you're guilty. You don't have to do anything. But anyway, that's up to you. Mr. Benjamin, do you have any motions yourself today? Your Honor, the state has no motions. Okay, then the last thing we have for today is arraignment. So as you may know, an arraignment is simply a process which you plead guilty or not guilty, and then that moves the matter to a trial. So are you ready to enter the plea today, sir? Yes, sir. And what is your plea today? Not guilty. Of course. So I'm going to accept your plea of not guilty, and we're going to set this matter for trial. Again, since this matter has had a lot of motions and we know for sure it will go for trial, let's set this for a date that is available for everybody, and it won't be your usual criminal date. It will be an actual trial date, much like today. Are there any suggestions by Mr. Benjamin, your office, or calendar? We'll start with Mr. Benjamin. Do you have any dates that you aren't available or cannot make? I'm available anytime, sir. Okay. I mean, we can have it, and again, let me stress, there is not a rush to have this trial. We're going to be here every day anyway.